Hello students, how are you? I hope you all are fine. Let's do the topic of Khulla and Mubarat and Muslims. You see, generally and usually it is the husband, Muslim husband who initiates the divorce. It is the husband, Muslim husband who pronounces divorce on his wife. And divorce is of three types: talaq ul ahsan, talaq ul hasan, and triple divorce or talaq ul biddat, which has been banned. This third one is banned by the Supreme Court of India in 2017 in Shahra Bano case. We have already done it in the earlier video. But the other two are still there, talaqul hasan and ahsan. So generally it is the Muslim husband who pronounces divorce upon her wife. But in Khulla, it is the wife who is the initiator of the divorce. It is the wife who actually offers this type of divorce to the husband. She makes the offer to the husband. It's not the husband who is making this, pronouncing this. It's the wife who is making an offer. So she wants dissolution of marriage and she makes an offer to her husband, and they may agree. Husband may agree to his offer, to her offer. The thing is that she has to pay a price for that. She has to actually purchase this divorce from her husband. In Khulla, the wife is the initiator of the divorce. She makes an offer to her husband. She has to pay a consideration for that. And husband has to agree for that. Husband has to accept that. Until and unless the husband does not accept that offer, Khulla is no more. There is no Khulla. Khulla is completed only when the offer of the wife is accepted by the husband, and she has to pay a price for that. She can get dissolution of marriage, she can get away from her husband only by giving him a price. That price may be a sum of money, that consideration may be a landed property or some movable property of the wife. So she actually has to give some consideration to the husband. She actually purchases that divorce from her husband. She has to pay something to the husband. So this is the concept of Khulla. And the important thing is that both husband and wife must be adult. They both must be having free consent for this Khulla, and they must be having the intention to get Khulla. Husband must agree to the offer given by the wife. He must not make some counter offer. He has to agree to the offer made by the wife. He has to accept the consideration given by the wife. And most importantly, once again I am saying that it is the wife who is the initiator of this type of offer. It's not the husband. In Mubarat, which we will be doing afterwards, both husband and wife are making the offers. Both are equally, both are having intention to get rid of each other. So in Mubarak, it is both of them who are making offer. But in Khulla, it is only the wife who is the initiator of the offer. Mubarak we will be doing afterwards. Let's complete Khulla. So what are the formalities for Khulla? Actually, for Khulla, the wife has to file a suit in the family court or Sharia court, and she may give an affidavit, or she may say on oath that she no longer wants to, or she is not able to live with her husband within the limits prescribed by Allah. So she is not able to live with her husband because of some reasons. You see, here in Khulla, she need not to give any reasons for that. She need not to point out any fault grounds for the husband, because actually she purchases this divorce. So only what she can say is that she is not able to live with her husband within the limits prescribed by Allah, or like this. She may make a statement on oath. But besides this, she can also, if she want to, she need not to, but if she want to give any fault grounds, she can say that, for example, her husband has deserted her for at least 4 years, and he's not maintaining her for 2 years. He has married a second wife, and he has been imprisoned for 7 years. These are some of the grounds. These are some of the fault grounds which she may point out in the suit for Khulla. He has not maintained her for 3 years. He has not performed his marital obligations for 3 years, and he is impotent from the time of marriage. He is insane for 2 years. He has been guilty of cruelty, physical cruelty, mental torture, whatever. These are so many things. These are similar grounds as given in the Dissolution of Muslim Marriage Act. So at the time of Khulla suit, the wife usually has to return her this dower or meher taken from her husband during marriage. For example, prompt dower, she has to return it to the husband in the court, in the family court. She has to return that property to her husband, and even the gifts received from her husband, she has to return that. Then only she will get Khulla, na? If she is ready to return the gifts given by the husband or some whatever she has taken benefit from her husband, all that property has to be given to the husband, and that property is known as Zare Khulla. This property is known as Zare Khulla. So, but besides this, gifts received from husband's family need not to be returned. Actually, it is the court who will decide what to be returned, and what not to be returned. It is the family court or Sharia court who will decide what has to be returned to the husband and what property has not to be returned. So it's all upon the court. As already told earlier, wife's failure to pay Zare Khulla does not render Khulla ineffective. Khulla is there. Khulla is already completed. The only thing is that if wife does not pay the price or money or whatever agreed upon, husband has to file a separate suit for that, and he can recover Zare Khulla from the wife through court. Now going to Mubarat, coming to Mubarat. Mubarat is also a type of mutual divorce, and basically in Mubarat both husband and wife are the initiator of the divorce. It's not the wife only as in Khulla. In Mubarat both husband and wife are the initiator. Both wants divorce from each other, and it's mutual agreement, and they are equally interested. Both of them are equally interested in the dissolution of marriage. So no party is legally bound to compensate the other party. As in Khulla, it is the wife who has to pay the price. She has to give some property, or she has to return dower to the husband. But in Mubarat, she need not to do this, nor the husband has to give some property to the wife, neither the wife has to give some property to the husband. Both of them mutually agree to divorce from each other, get divorce from each other. So basically it is akin to or similar to mutual divorce as mentioned in section 13B of Hindu Marriage Act and section 24 of Special Marriage Act. Otherwise all the formalities or the conditions of Khulla apply in Mubarat. All the conditions which we have done earlier in Khulla, it applies in Mubarat. The thing is that similar, she has to go to court, both of them to go to the court, and they have to file this case of Mubarat. Everything is same. The thing is that in Khulla it is the wife who is the initiator of this type of divorce, but in Mubarat both of them are initiator. Actually both of them want this type of divorce, and they mutually agree to get divorce from the court, from family court or Sharia court, and there is no need of paying any price to each other in Mubarat. So Khulla and Mubarat, a type of mutual divorce in Muslims. I hope you like the lecture. Do comment on the video so that I can learn from your comments and upload more and more videos. So thank you very much. Best of luck.